views and opinions expressed in this program are those of the participants and do not necessarily reflect the views of BronxNet or the program underwriters.
Well, coming up on this edition of Today's Verdict, when it comes to protecting your privacy, do you ever really know if someone is watching or listening to you without your knowledge? Well, tonight we'll get the chance to sit down with an attorney who will discuss the issue of unlawful audio and video surveillance. Later in the show, we dive right into your right to defend yourself from an attack by both a civilian and law enforcement attack. It's Self-Defense 101. As you can see, we have much to get to, so stay tuned. Today's Verdict starts right now. Hello, and welcome to Today's Verdict, the live and interactive show that gives you your legal rights and options. I'm your host and trial attorney, David Lesh. Well, Today's Verdict is always encouraging you to stay connected. Make sure to tweet us at Today's Verdict and hashtag Ask Today's Verdict if you have a question. Also, make sure to like us and follow us on Facebook at Today's Verdict, and check us out at BronxNet.tv/BronxLegal. And last, but certainly not least, don't forget to tweet me at David Lesh. Well, New York's penal law prohibits electronic invasions of privacy, otherwise known as unlawful surveillance. Well, installing a hidden camera to record your movements without someone's consent or even eavesdrop a conversation is an illegal action. Well, joining us today to help us get a better understanding is attorney Eric Arnone. Eric, thank you so much for being here.
Thanks for having me, David.
Listen, we're going to break this up into two parts. Let's first start with audio. I know most of the viewers really want to know a little about the video, so much video cameras all over the place. Let's get into audio first. When you're listening to a conversation, what is the law with respect to your ability to record somebody else having a conversation without them knowing you're recording?
Well, New York is what's called a one-party state. So long as one party to a conversation is aware and consents to the recording of the conversation, there's no problem. But you run into problems if a party tries to overhear two other people talking, two other people who are not aware that you're recording and do not consent. That would be eavesdropping.
You know, I always had a doctor who used to call my office, and I always knew that he had a recording device on his phone. And sometimes he would say he was recording me and sometimes he wasn't, but that's perfectly legal because it's his conversation with me, am I correct?
Exactly, as long as the doctor knew and consented, then it didn't matter if you did not.
Right. Now, if the doctor, though, was recording another conversation, let's say your and I conversation, you and I were talking, that's no good. Okay, that's really what's called eavesdropping. And that's where we draw the line. So if you're not a party to it, that's what the reviewers have to really understand this. If you're not the party to the conversation, no good.
That's correct. And a lot of my clients ask me, if they have domestic situations or situations where they're trying to get other people who are party to litigation to make comments, they ask us if it's permissible for them to record, and we tell them as long as you're aware and you're consenting, that's enough.
That's enough. All right. Moving along, again, talking about audio, I thought this was very interesting too. Courthouses. You would think, you're in a trial court, or I'm on trial, let's say. I have somebody in the back using an iPhone and recording. Can't do that, can you?
No, you cannot. There are signs posted all over the courthouse specifically indicating that no one can record audio or video. Right. Unless, of course, there's an exception for the press. If they obtain a court order and the judge approves it, then they can record.
It's funny. It seems like the appellate courts may allow it at certain times. The federal courts may allow it, but you would think in a public domain in this way, because we're going to get to public domain in a second, which isn't really a trial, a public domain, but the answer is no, you can't do it. It's something that people should understand because you don't want to go into a courthouse and start recording, am I correct?
Absolutely not.
All right, so that's good. All right, let's, speaking of public meetings, and when we say public meetings, we're talking about governmental meetings. There's a governmental's calling a meeting together, and we're going to discuss what we're going to do with respect to taxes or something. Can you record that?
I think the general rule is that so long as you don't have a specific prohibition, such as a posting in a courthouse where indicating that you can't film or audio record, there's no prohibition on filming public occurrences.
You can do that.
That's sort of the general blanket rule that there's no restriction on that.
Okay. Now, let's get into the guts of it, and really people are more concerned about the video.
Right.
Because, people don't like to being audio recorded, but they really don't want to be video recorded, and they don't love it's thrown on Snapchat, or it's thrown on YouTube, or it's put in a lot of different places. So let's talk a little bit about video. And first, let's start with the workplace, if we can. What is the law with respect to videotaping, if you know, and the best you can tell us, employer-employee video surveillance?
I think the important thing to understand about video recording is the public and private distinction. So any area where an employee has a reasonable expectation of privacy, whether or not it's a bathroom or a changing room or a dressing room, any place where that employee would expect to remain private, the employer cannot record them. Other areas, common work areas, hallways, elevators, obviously there are cameras everywhere. There's no restriction on that.
It always seems that it's that expectation of privacy.
Right.
And that's really what it comes down to. But I'm sure there are some fuzzy areas in every single work office area where some people can say, yeah, I change here, or I do something private here, and why is my employer camera pointed at me?
Well, that's where the reasonable prong comes into play. If you're changing in a bathroom, then I think your expectation of privacy is reasonable. If you're changing by the water cooler and you're caught on camera, clearly your expectation of privacy is not reasonable. So the law has a built-in mechanism.
And by the way, I'm not really being fair to you, because your realm is in the criminal area.
That's right.
I mean, let's tell the public the kind of work that you do, by the way.
Sure. Well, currently I'm a defense attorney. I was a DA in Manhattan for 10 years in the trial division and the homicide investigation unit. And now for the past 6 years I've been practicing privately.
All right, before I tap into your expertise in terms of...
No pun intended.
Exactly. Before I tap into your expertise in terms of the criminal surveillance and law enforcement and different things, let's stay a little more in the civil area. It's my area, and I'm interested in it,
Sure.
and a lot of the other viewers I know are as well. From what I understand in the employer-employee relationship, if you retaliate, in other words, if you as an employer say, hey, you've been, trying to drop a dime on me with respect to the press, or being a little bit of a whistleblower, that type of stuff, I'm going to retaliate and now videotape you just at your desk, which I normally could do, but you can't do that now, can you?
This is probably more of your level of expertise,
Okay.
but I think there certainly are laws that are designed to protect whistleblowers and specifically prohibit that type of retaliatory conduct.
Listen, I was reading, interesting, I thought that this was interesting, and I don't know whether you agree with it or not. It was a casino where there was somebody who was apparently, giving the casino a hard time in terms of whether they were properly allocating money or giving money out to the employees, and they kept recording him, and just him, all the time whenever he was either dealing or doing different things, and he brought an action, and they said it was retaliatory. And he was awarded damages, which I thought was very interesting. And the damages are, I don't know if you know in the civil area, it's intentional infliction of emotional distress or negligent infliction of emotional distress. So you can be successful in bringing actions against employers for this type of thing if it's retaliatory.
And I guess the takeaway from that is it's really a case-by-case basis. I don't think there's a blanket rule on employers being prohibited from recording their employees, but in a situation like that where they're targeting somebody, clearly he had a prima facie tort in
Absolutely.
that case, so it's a case-by-case. There's no blanket rule.
Okay, let's get into a little bit of what you do, and let's talk a little bit about police enforcement, and when you think you can record the police doing something against you, you can't, and we see it all the time in the news. Somebody always has a video camera out, and there's a police officer trying to knock it away, or tell me a little bit about this.
This is the hot button issue now. Everybody's got a camera and they're built into their phone, and everybody's recording police interactions with civilians. Your viewers should be completely aware that there is an absolute right to use your phone and record in the public, so long as you're not violating another law. And an example of a violation of another law might be trespassing, so you can't trespass and record.
Sure.
If you're going to record police interactions, there's nothing wrong with that, but I always caution the public and my clients and my friends that you need to be careful that you don't interfere with the police officers as they carry out their duties. If you do so, you can commit an additional crime, obstructing governmental administration, disorderly conduct, and I've represented people who have started the interaction filming someone else being arrested, and next thing you know, they found themselves in handcuffs. So I say, if you're going to do it, don't have any contact with the officers. Certainly don't have any physical contact with the officers. Stay a safe distance away. And to be perfectly honest with you, if the officers tell you back up 10 feet, 15 feet, just do it.
But you could still have the camera out, though.
Absolutely. There's nothing prohibiting you from doing that, so long as you're not interfering with the officers carrying out their lawful duties.
And you probably think if a police officer does have a camera pointed at them, they're going to be a little more apt to follow the rule of the law.
One might think that, although
doesn't
some of the
always
recent
happen.
events in the press might belie that claim. But look, the police have cameras too, so why not have the civilians film?
You know, it's an interesting debate. Somebody asked me recently why they think there's been so much hostility between the public and law enforcement over the last couple of years. And I tweeted this out, and I completely agree with this. I think it's two reasons. It's cameras and social media. And if you didn't have the cameras that show what's going on with the police officers in the community, and you didn't have the social media to get the video out to the world, you really wouldn't know. And I think it's so important that we have a chance in society to see what's really going on when there's an arrest that's made. A lot of these things are swept right under the rug. Think how many crimes have been committed by police officers. You would never know it if there wasn't a video. Am I right?
I agree 100% with you on that.
So,
yeah,
know, that's my position.
I agree.
I want to ask you some questions now that I got some from the internet, a few from some viewers. Interesting stuff, and see what you think about this. Okay.
Sure.
For posting a video on YouTube, do I need written consent from people in the background?
No, you're free to post on YouTube. Again, so long as you're not violating any of these other statutes.
So let me get this straight. All right, so I'm walking around, somebody's doing a YouTube video, and I happen to be in the background, walking on the street, and they take a picture, and I'm not dressed too well, my tie's all off, okay, I'm sweating, and that video goes viral, and everyone sees me looking disheveled and horrendous. I don't have a lawsuit for this.
No, you're in the video. Again, the law is looking at whether or not your expectation of privacy is reasonable or not. And if you're walking down the street in this day and age, your expectation essentially has to be that you're going to be caught on someone's camera. Everyone's got one.
I guess every tourist in the world would be arrested if.
Precisely, exactly.
Okay, here's another question. I thought this was a good one. Is it legal in New York City to have a video camera inside an apartment without letting you know it's there?
This is a good question. And again, we have to be careful about, or I have to be careful about it, administering blanket legal advice and saying it's legal or not. My gut feeling when I hear a fact pattern like that is that we're drifting very close to the unlawful surveillance statute. If you have a camera that's placed in an area where it's going to capture images which may contain someone changing or engaging in sexual acts or just any private acts, then you need to understand that you're exposing yourself to liability under this statute. Now, arguably, a distinction could be made, and again, we're talking in the criminal realm here
absolutely.
between the unlawful surveillance statute. If the argument is going to be made that the camera was placed in a common area of the apartment or the dwelling where that person wouldn't expect to capture those types of intimate images, then that's not an argument I've seen or a fact pattern I've seen just yet. But I think you're getting dangerously close to the unlawful surveillance statute.
By the way, we don't have much time. Where do we find you? Let's give some contact information if we could do it right
Sure.
now. We can have it on the screen, but also if you could tell us.
Sure. Well, our office is downtown. Our main number is 212-323-7408. The firm is Galuzzo and Arnone.
Got it up there. Last thing before we let you leave, someone's watching. Some tips you would give to somebody who thinks they're unlawfully arrested because they've been videoed, because they videoed a police officer that they shouldn't have videoed, or maybe they think that somebody has been surreptitiously videotaping them. What do you say?
Well, those were two very brief situations. And the second is the easier one. I think they need to contact the police. If you think someone is recording you, then you're a potential victim.
Okay.
And in the former situation, you got to contact an attorney because you might end up in court.
Got to contact you.
Contact us.
All right, and
we've handled cases like that before.
And you're going to come back and we can talk a little bit about what's been going on in the press, because I'm sure in the next 6 months we'll see a lot more video and, unfortunately, people who are being arrested for taking video.
I'd love to. I have a lot to say about that as well.
All right. Well, we have to take a quick break, but don't worry. We'll be back with more Today's Verdict right after this.
There's a shelter pet who wants to meet you. Meet one today. Visit theshelterpetproject.org. Adopt.
Adopting a new pet is a rewarding experience. And shelter pets make super pets. Your new best friend will steal your heart, bring you happiness, and enrich your life for years to come. You can make a difference in the life of an animal. Adopt and bring home a shelter pet today. To find out more, visit theshelterpetproject.org.
Hey, I'm Darren Jaime. I'm the host of Wednesdays Open right here on BronxNet Television, channel 67, and also on Verizon Files, channel 33. Want to invite you every Wednesday. You get an opportunity to see what's going on in the world of news, current events, debates, public information. That's what happens here on Open every Wednesday. So we invite you to join us right here on BronxNet Television.
Wow, these are really good.
You act surprised. Practice makes perfect.
You don't have to be perfect to be a perfect parent. There are thousands of teens in foster care who don't need perfection. They need you.
It's not always easy being a dad.
Do you have panda asthma too? Does that run in the family? This is the home of the most priceless kung fu artifacts.
But when you make an effort,
Dad, we're not supposed to touch anything.
Oh, sorry.
Go long, son.
it's always worth it.
Whoa, faster!
The smallest moments can have the biggest impact on a child's life. Take time to be a dad today.
I am gonna get you. I'm gonna get you.
Call 877-4DAD-411 or visit fatherhood.gov to learn more.
Welcome back to Today's Verdict. I'm your host, David Lesh. We are always encouraging you to stay connected. Tweet us at Today's Verdict. Now, when it comes to a threatening situation, it is not illegal to defend yourself, even if the result turns out to be murder. However, there are limits to the defense. Joining us today to give us a lesson on your right to protect yourself is criminal defense attorney John Booza. I probably should correct myself that if you kill somebody, it's really not murder. It would be self-defense. You really shouldn't say murder, but that's what I'm trying to get across.
It's a homicide.
It's a homicide. I like that better. All right, John, let's talk a little bit about a couple of legal doctrines first. And the first one I find fascinating is the New York Castle Doctrine. A man's home is his castle. Tell us a little bit about what that means.
So I'm going to start by saying New York is not a stand-your-ground state.
Fair enough.
What that means is that if you're using deadly physical force, guns, knives, shooting, anything that can cause serious physical injury or death, in New York, you have to essentially retreat to safety if you reasonably believe that you can do so. So you cannot stand your ground if you think you can get away safely.
New York, not a stand-your-ground state.
And the reason
Tell me.
I'm sorry. The reason I jumped the gun there is because the Castle Doctrine means that in your home, though, that does not apply.
You could stand your ground.
You could stand your ground in your home.
You know, I remember from law school way back when, there was that case with the shotgun that was pointed at the, that you had it rigged up, and the minute they opened up the door, the shotgun, blew the person away. And you'd say, well, hey, he came into my house, and I can stand my ground, but that didn't really hold water because there was you could hold your ground in your home, but you still have to have some type of reasonableness in terms of your ability to defend yourself. Am I correct?
Yes. So in New York, there's the very famous Bernie Goetz situation.
Sure.
In the early 80s, guy was out taking a train, and some guys, maybe or maybe not, were going to rob him. He shot them, and then towards the end, he looked at one of those guys and said, "You don't look so bad. Here, have another," and shot him again. That case was seminal in the New York's self-defense law, and that's People v. Goetz. Okay, and that case basically says that in determining whether a person is acting in self-defense, really there are two questions that need to be asked. One is, did the person honestly believe that they had to use the level of force necessary to protect themselves? The reason I say that is because if they're using deadly physical force, then they need to honestly believe that deadly physical force is being used against them or somebody else. So they have to honestly believe that it's necessary.
Well, let's take a step back here,
Sure.
because there's a difference between physical force and deadly physical force.
Yes.
What's the difference?
Deadly physical force is legally defined as force which is likely to cause either serious physical injury or death.
And physical force is you can hit them in the face and they're not going to die.
Correct.
Really, that
Punching,
kind of thing.
kicking,
So
pushing.
an eye for an eye kind of thinking when it comes to the self-defense.
Yes.
All right. Now, here's where I get a little confused,
Mm-hmm.
and maybe you can enlighten me here. The subjectiveness of your own intent, your mens rea,
Right.
differs from person to person, right? Let's say I'm a very jittery person. I don't like horror movies. I get very scared at loud noises, a big bang, I'm jumping around. And you're cool as a cucumber. But now I'm confronted with somebody that I am so afraid is going to kill me. Yet you would be, this isn't as bad as it's going to be. I can get out of this. I can talk through it. I pull out the gun. You talk it through. Am I still protected if my own subjectiveness says that I was so scared where a reasonable person would not be so scared?
It depends.
It does.
Okay, so in that particular situation, so the first prong is that the person has to subjectively believe that they need to use the force necessary.
Fine.
The second prong, though, and they both have to be met, is that belief has to be what's called objectively reasonable.
So what's the point of the subjective? What's the point of the first prong is really what I'm saying. Because if the jurors have to stand not in my shoes, but in their own shoes and say, hey, a reasonable person, because we're reasonable, and let's think of somebody reasonable that I know, that reasonable person would not have pulled the gun. We're sending Mr. Lesh to jail.
Suppose, hypothetically speaking, that I'm
Sure.
really good friends with Whitey Bulger.
Okay.
Okay? I've known him my whole life. He's a really good friend of mine. And I know what makes him tick and what doesn't, and I know when he's going to commit violence and when he's not.
Okay.
Whitey Bulger, let's say, a guy I know forever, pulls a gun on me in jest. I know he's joking, subjectively. A reasonable person in that situation might believe that they need to use serious physical injury,
Sure.
serious physical force to protect themselves, whereas I, because I subjectively don't think it's necessary, would still be guilty of murder if I kill him. So you have to have both prongs there.
That's a great example. All right, let's talk a little bit now about the news and the press and what's been going on with whether you should be able to stand your ground and not stand your ground. What is your feeling on society lately? Because there's been such a disconnect with the police.
So I will start by saying that self-defense law in any jurisdiction, especially in New York, is very complicated. And what that means is that you're relying on judges, prosecutors, defense attorneys, police officers to sort of get it right. And when you are using deadly physical force, you're relying on a lot of people giving you every benefit of the doubt. Sometimes when there's a dead body, they may not want to do that. So New York has the requirement that if you're using deadly physical force, and if you, again, reasonably believe that you can retreat to safety, you are required to do so.
You are required.
You're required to do so, yes.
Now,
unless you're in your home.
Now, right, unless you're in your home. But now let's talk about what it means, what an affirmative defense is, because I don't think the public understands what that means. In other words, sometimes you have to plead something as opposed to something being proven against you.
Right.
So let's talk a little bit about what that means.
So in New York, the government has to prove every element of, in a criminal case, every element of the crimes charged beyond a reasonable doubt. There are certain defenses in which case you're basically saying, yes, I did that, but here are the unique circumstances that make me not guilty of the crime or make me lesser guilty.
And you have that responsibility
Yes.
to prove that, Ellen, and that's called the affirmative defense.
Correct.
In other words, so you got to take the stand, because if you don't take the stand to prove it, you're not proving your defense, or you don't necessarily have to take the stand, but
yes.
You have to prove it. So it's an affirmative defense, am I correct?
So I'm glad you brought this up. In New York, it is not.
It is not an affirmative
Not an
defense.
affirmative defense, yes. So if there is a reasonable view of the evidence that the person was acting in self-defense, then the prosecutor has to disprove it beyond a reasonable doubt.
Which is much harder to do.
Yes.
All right. What kind of evidence? Now, you've been on both sides of the fence, right? As a prosecutor, what kind of evidence are you trying to present? As a prosecutor now, let's
Yes.
put that hat on first. To show that this person truly believed he was not acting in self-defense?
These situations are very fluid always.
Okay.
Okay. There are certain circumstances where you are legally not entitled to self-defense, even though it gets there. If you're the first aggressor, as I said before, if you can retreat to safety, you can't use deadly physical force. What I'm looking for as a prosecutor is it revenge? Guy punches me in the face, makes me look bad. I'm going to pull out a gun and shoot him now. Can I pull out a gun and shoot somebody that is punching me in the face? It depends. But what I'm looking for is the reaction, is it proportional to what is being done?
And what do you do as experts? Do you use psychiatrists? What do you use to figure out what's in the mind of the person that's doing the...
What I do is what I ask any juror to do. It doesn't matter what side I'm on. You have to put yourself in the mind of everybody involved. So you have to put yourself in the mind of the attacker, and you have to put yourself in the mind of the defendant. And you have to say, what would I do in that situation?
All right, now let's put on your criminal defense act, because that's what you do.
Sure.
All right. How do you go about protecting somebody who is accused of this type of crime?
Well, the first thing I do is I think of the case like a prosecutor, because that's what they're going to do. And I need to know how is it that they're going to prove that my client is guilty? And then what I do is I try to disprove it. And I look at the things that matter, things that are sort of probative of proving or disproving, and we take it from there.
Do you find a sympathetic jury, sympathetic society?
Always, yeah.
Do you find that?
Yeah, no, absolutely. There's what the law says and there's what people think the law is. And your jurors are always going to be people on the street.
Contact information quick so we know where to get you.
Sure. 212-349-2200, johnboozalaw.com.
And you're going to come back maybe
Sure.
6
Yeah,
months, a year?
Whenever you want me.
Keep going?
Yeah.
All right, well, that's all the time we have for tonight. I'd like to thank our guests for joining us, and of course you, the viewers, for watching. If you missed any part of today's show, be sure to check it out at www.BronxNet.tv. Also remember, if there is a legal issue or topic you'd like to see on a future edition of Today's Verdict, feel free to contact me at davidlesh@BronxNet.org or tweet us at Today's Verdict. And make sure to hashtag Ask Today's Verdict. From myself and all of us at Today's Verdict, always remember, know your rights, know your issues, reach a verdict. I'm David Lesh, and we will see you again in 2 weeks with an all-new episode of Today's Verdict right here. See you next week.